So just a quick reminder, the clinics were born out of our IDRN, our referral and support space. So for those of you who are not subscribed to the IDRN, which I think many of you might be, you will find all of our previous clinic and the recording to this clinic after the session on there. I've added a link to the chat, so just click on that and you can register there for free or log in at your leisure. And so without further ado, I'm going to hand over to Henry and Georgina. Henry is making his debut in our clinic today, and he will be presenting on claims by independent adult children under the 1975 Act. So thank you, Henry.
Perfect. Thank you, Lindsay. So, yeah, hello, everyone. Thank you for joining the Contentious Clinic. As Lindsay said, I'm Henry. I'm a solicitor in the team here at IDR Law. I'm accompanied by my colleague Georgie, who's also a solicitor here at IDR Law too. And yes, we will indeed be touching on the Inheritance Act today, and in particular independent adult children claims. So we'll try to sort of cover the content in around about 30 to 40 minutes, all being well. Hopefully we don't run over that sort of allotted time. As Lindsay said, if you want to put some questions in the chat box, we'll try to get to those at the end if we can, but we might be limited with time, in which case you can always email us, and our emails are on the final slide of this talk. So turning to the objectives of today's webinar, so what we're going to cover, I will provide an overview of the 75 Act, which I'm sure most of you as attendees will be familiar with anyway, but yeah, provide an overview of that with a focus on claims brought by independent adult children. Georgie will then talk you through the factors that the court will consider when dealing with these types of claims, and will refer you to some key case law in the area as well. I will then be applying the relevant factors to a recent case that we have dealt with here at IDR Law, and then I'll conclude with a sort of short summary, setting out some hopefully practical and helpful tips and considerations when dealing with 75 Act claims. So, the 75 Act, starting point really is to look at section 1.1 of the Act. So what this does is it confirms that, or gives certain individuals the opportunity to make a claim for provision where they feel they've not been reasonably provided for in the will or under the rules of intestacy. So the first consideration is whether the potential applicant is an eligible claimant and therefore eligible to bring a claim. Where we're talking about adult children, we're going to be referring to primarily section 1.1c, which captures any sort of natural child of the deceased, and also section 1.1d as well, for someone who is treated as a child of the family, which, as it says on the slide there, comes to the aid of stepchildren. There is also section 1.1e, which is a sort of fallback option, I suppose, where an applicant is looking to bring a claim as someone who is maintained or was maintained by the deceased. But for the purpose of today's webinar, we will primarily be focusing on section 1.1c there and section 1.1d as well. So the key questions that the court will ask, point one, as it says there, has the claimant been left with reasonable financial provision from the deceased estate? And if not, what is reasonable financial circumstances, reasonable financial provision in the circumstances, should I say? So, where adult children are concerned, we look to section 1.2b of the 1975 Act, and as it says on the slide, reasonable financial provision in the case of independent adult children will be such financial provision as it would be reasonable in all the circumstances of the case for the applicant to receive for his or her maintenance. This is commonly referred to as the maintenance standard. An important point to note at the outset really is that there is no sort of automatic entitlement. So just because you do qualify, just because you are a child of the deceased, does not mean that you are automatically entitled. And the applicant will need to show that they have not been left with reasonable financial provision for his or her maintenance. It's also worth highlighting that it's not for the court to decide whether what the deceased ought to have left to the applicant or whether it was fair. The question that's being asked of the court is whether the applicant has been left reasonable financial provision from the deceased estate for his or her maintenance. So in summary, independent adult children's claims are needs-based claims, and so, but as it states there, need is not necessarily always sufficient, and in most cases you might need something more than just need. But in considering the topic of maintenance, we need to obviously consider what is maintenance, how that's been determined. So turning to Eilert and Mitson, which is a sort of landmark case in this area, it was confirmed that the concept of maintenance is broad, but it cannot extend to everything desirable for an applicant to have. And it was said that we must import provision to meet everyday standards of living, which would include provision for housing. This was quite neatly summarised in Reed Dennis in 1981, which was approved in Eilert and referenced in Eilert, where Justice Brown Wilkinson said, "In my judgment, the word maintenance connotes only payments which directly or indirectly enable the applicant in the future to discharge the cost of his daily living at whatever standard of living is appropriate to him." And case law has shown maintenance to include a lump sum to satisfy an applicant's housing need, a lump sum for income, payments of existing debts in certain circumstances. So, for instance, to pay debts to enable him or her to carry on running a profit-making business, for example, maintenance to cover food and fuel costs, white goods, a reliable car, and even holidays. But it's important to note that the maintenance standard is not designed to confer a capital windfall on the applicant, which is often a point that can be misunderstood. It has, however, been shown that, as I say, that independent adult children will need to show something more than just need. So turning to the next slide, the need for maintenance was again addressed in the Eilert case, and where Lord Hughes says the need for maintenance rather than for anything else is a necessary but not a sufficient condition for an order. Need plus the relevant relationship to qualify the claimant is not always enough. And then further quote there from Lord Hughes in citing the case of Re Coventry, touches on the fact that often, in addition to being an eligible claimant and having need, there will typically need to be something more, and he makes reference there to a moral claim, as it has sometimes been referred to. His Honour Judge Paul Matthews also declared in Ball and Ball that need so ascertained is not enough by itself to justify the court going on to make an order. It is not automatic. There must be something else. It may be a moral claim, or it may be some other circumstances. So in summary, you need something more, something special, if you like, to succeed as an independent adult child. So examples of that that we've seen, it could be disability, it could be impecunious circumstances, it could be sexual or psychological abuse. In the case of Eilert, there was one of the sort of central factors was the point that there was no real connection between the deceased and the charities, and that was certainly a relevant factor. But generally, these things will tend to be connected to the deceased in some way. So, for example, the deceased caused an estrangement and subsequently perpetuated that estrangement. So, moving on, to the powers that the court have to make orders. So they're set out in Section 2 of the 75 Act. I won't sort of bore you by reading through those, but they are on the slide there. So if the court believe that an applicant is deserving of an award, then they can make an order on those terms. The bottom point is also quite an important point, just to sort of hit home really, or reiterate, in that case law has shown that the maintenance standard is, again, not designed to confer a capital windfall on the applicant. And so, for example, even though a lump sum can be awarded, it should only be used to discharge or satisfy an applicant's maintenance needs. So I'll now pass you over to Georgie, who's going to touch on some of the case law in this area.
Thanks, Henry. So yeah, I suppose the question is here, is how easy is it to succeed as an adult claimant under the 1975 Act claim? And the answer is, well, it really isn't easy in practicality. So on the left, we've outlined some cases where adult children were awarded nothing at trial, so were unsuccessful. We won't discuss these directly today for reasons of time, but you can obviously have a look at any summaries of those in your own time if you wish to do so. On the right are, however, some successful cases, which I'll briefly detail. So first of all, we have Nahayek versus Fowl. So in this case, the starting point was that no financial provision at all had been made for the applicant, being the deceased child. The deceased, in this case, had provided his estate completely to a friend in its entirety. The claim was ultimately successful, and the applicant was awarded £30,000. That is bearing in mind a £30,000 award against an estate value of around £265,000. So in REH 2020, the starting point here was that no financial provision was made for the applicant. The deceased wife was actually the sole beneficiary of his will, but it was argued that she had little need as she was already in a care home. It is, however, worth noting that the judge did express that had the situation been different, that provision for the wife here was or would have been the absolute priority. The claim was ultimately successful, however, and the applicant was awarded £138,918. This comprised of an award of around £100,000 and then about half of the excess above that, a direct contribution to the claimant's success fee, as they were acting under a conditional fee arrangement, or the firm representing them were. So this was against a net estate which had £142,000 worth of cash available. However, the deceased wife had already inherited by survivorship a joint bank account and the matrimonial home, which was worth around £800,000. In Rochford versus Rochford, we have Miss Rochford, who is the only daughter of the deceased, and was left £25,000 under the deceased will. The bulk of the estate, however, was left to the deceased sister, so Miss Rochford's aunt. Miss Rochford argued that she was going to suffer a significant income gap from the point she turned 60, as she would lose the benefit of an income protection policy, and this was between that and when she would be able to claim her state pension, a period of around 7 years. On this basis, she was successful in her claim and received a further £85,000 in addition to the £25,000 she was left under the will. The £85,000, however, was reduced slightly from what was originally going to be awarded on account of the modest value of the estate, which was only around £190,000. And then finally, in Higgins versus Morgan, the starting point was that no financial provision was made again. But in this case, the applicant was actually the deceased stepson. So the estate, as well as there was no will, so the estate ordinarily would have passed under the rules of intestacy to distant cousins. The claim was actually ultimately successful, and the applicant was awarded £48,800, which was increased then to £55,000 to take a contribution for his success fee. This was based on a net estate value of £195,000. That was what the award was based on in any event, although it wasn't really directly agreed between the parties what the net estate actually comprised. It's therefore sort of, although some cases are ultimately successful, we are talking generally that typically relatively modest sums are awarded by the courts in these sorts of cases. So that's also something to consider if you are considering taking on a matter of this type, and especially pursuing that all the way to trial. So now I'm just going to move on to the factors that the court considers in independent adult children claims. So the court will look at several factors. These are commonly known as the Section 3 factors and are contained in Section 3 of the 1975 Act. So it's sort of an exercise that the court will go through. They'll consider all of these various elements when deciding whether it would be appropriate to make an award. So the first one would be the finances and resources of all claimants or beneficiaries now and in the future. So this also includes any intestate beneficiaries, so beneficiaries who would inherit on intestacy. So it's therefore not just the financial position of the person actually seeking to make the claim that will be considered, but the court may also have regard to the needs of any other beneficiary or claimant, which is more significant. Normally, you'd expect someone to put forward what's called a needs-based defence in that circumstance, but sometimes needs are just considered in general of other beneficiaries who perhaps also have an equal or more significant need for funds within an estate. The second is the obligations and responsibilities the deceased had to any applicant or beneficiary. So this could be various things. For example, a deceased may be paid for certain treatments, private treatment for the person who's been maintained to have, or it could be a certain allowance that they gave them every month, for example. The size and nature of the estate, so that's obviously relevant in terms of what we've just discussed in terms of how that award is actually seen in relation to the general net estate and what is available. Any disabilities of any applicant or beneficiary. Anything else the court may consider, i.e. the conduct of any party, and also the manner in which the applicant was being, or in which they might be expected to be educated or trained. I would say that this is a factor which is it's unique to sort of child claims or adult children claims. However, generally, unless a claimant is of school or university age, it's not something that is generally dealt with that often on that particular point. So in terms of claims under Section 11D, there are additional factors that the court will need to consider. So these, as just a reminder, would be on the basis that a claimant was treated as a child of the family. So in these sorts of claims, the court will have regard to whether deceased maintained the applicant, length of time, and on the basis on which the deceased did so, the extent of any contributions made, whether the extent or to the extent the deceased assumed responsibility for the maintenance of the applicant. So that's sort of quite a balancing exercise, to judge sort of how great the maintenance was, I suppose, or how reliant a particular applicant was on the deceased. And then also sort of crucially, whether in maintaining that particular applicant, the deceased assumed that responsibility, being aware that the applicant was not their own child. So it's therefore quite crucial that if you're dealing with a claim from a non-biological or adoptive child, that you understand that the deceased was fully aware that the individual treated as their own child was not in fact their child. And as stated previously by Henry, maintenance in this sense is given quite a broad interpretation. So it could be, a sort of a little bit, it could be something that's, reasonably quite small, or it could be something quite significant that the court could sort of base an award on in that situation, really.
Perfect. Thank you, Georgie. So, turning to a recent case example, which in the case of Ree Larson, this is quite a useful case as it shows how the court will approach these sorts of claims. So in this case, the deceased was survived by 3 children, as it says there, Wayne, Russell and Heather. There was a gift of £10,000 to each of the 3 children, with the residue passing to spouse, but her spouse had predeceased. The residue of the deceased estate was to pass to Heather instead. Wayne and Russell were excluded as residuary beneficiaries on the basis that the deceased felt that they had not sort of demonstrated good or positive behaviour in the past, and that's why he chose to restrict their provision to that £10,000 gift. Wayne had previously been convicted of manslaughter, and Russell had quite a serious gambling habit, which led to him taking money from members of the family, and so it's believed that these were the reasons that that the deceased did not include them as residuary beneficiaries. Claims were, however, brought by Wayne and Russell. Wayne was sort of seeking to discharge a debt of £20,000, which was a bounce-back loan relating to his business. Also a statutory charge against his home of £40,000 and a lump sum to cover a monthly deficit or income shortfall for 3 years until his children were no longer dependent on him. Ultimately, Wayne's claim was dismissed. The judge felt that it was a business loan and not a personal loan. The statutory charge would be discharged when the property was later sold, and it was found that once the figures that Wayne had provided were sort of honed in on a little bit, it was found that the income deficit was actually quite inflated, and so it was determined that Wayne would receive the £10,000 gift only. And as I say, his claim was dismissed. Russell, on the other hand, he was chronically disabled. He suffered from Crohn's disease, anxiety, and spondylitis, and so he required help with everyday or ordinary tasks. The judge reviewed Russell's financial circumstances as part of those Section 3 factors that we've spoken about, and found that his financial needs were sort of just about met by his relatively low income, but Russell, in bringing his claim, did express concern in relation to his sort of future care costs, and sought a lump sum of £25,000 to cover this. The judge ultimately awarded £25,000 to be held on discretionary trust for Russell for the purpose of meeting his care needs. If Russell were to die before, or if Russell were to die without the need for care, then that sum or whatever was left of it was to revert to Heather as the residuary beneficiary. So that's hopefully quite a useful example of how two children in different circumstances will be looked at depending on their individual circumstances. Moving on, and to sort of build on this further, we've put together an example of a case that we've dealt with here at IDR Law, and ultimately we managed to settle this one before it even made its way to mediation, but it's again quite a useful example to consider. It is on the note of settlement and mediation, it is fair to say that the vast majority of these sorts of claims do tend to settle, and as I say, thankfully this one did too. So turning to the facts, we have Philip and Mandy. They were married for approximately 30 years. Philip then died. During their marriage, they shared a close relationship and shared their sort of finances throughout. Mandy was quite instrumental in sort of supporting Philip in building his business too. Equally, they did enjoy some challenges during their marriage, which is not uncommon, and not least Philip's issues with alcoholism in the early 2000s. So Philip only had one daughter, Ella, but Philip did also have a daughter from a previous relationship, Kylie, as it shows there. However, there were some queries around whether Kylie was indeed actually Philip's biological daughter. So the background or facts of the case, that Philip died with a will. The will appointed Mandy, his wife, as the sole executrix. It did leave a pecuniary legacy of £100,000 to Kylie, the daughter from a previous relationship, and the remainder of the estate was to pass to his wife, Mandy. The estate was worth approximately £1.4 million. That was made up of Philip's 50% share of the matrimonial home, which, as it says there, was owned as joint tenants and was subject to a sizable mortgage. So Philip's 50% share of the matrimonial home passed by survivorship to Mandy, and then there was also Philip's shares in the family business. Kylie sought to bring a claim under Section 11C of the 1975 Act as a child of the deceased. A bit further background. Kylie and Philip were estranged during part of Kylie's childhood, and contact was resumed at age 11. Contact thereafter took place in the form of telephone calls, and they saw Philip and Kylie saw one another approximately once per month. Philip provided Kylie with some financial support, normally in the form of purchasing items for Kylie's 3 children. And as a result, as I say, Kylie sought to argue or bring a claim under Section 11C of the 1975 Act, despite refusing to undergo a DNA test to prove she was a biological child of the deceased. I've referenced there Section 11D and Section 11E, just primarily to highlight that if Kylie had refused to undergo the DNA test but had issued her claim, then adverse inferences could have been drawn from this. And so it was considered that in an attempt to get around the DNA test issue, Kylie could have sought to rely on either of those 2 sections instead. Ultimately, the crux of Kylie's claim was that she sought to argue that she and Philip, whilst they maintained a close relationship, that they managed to maintain a close relationship despite Mandy and Ella's attempts to allegedly force an estrangement, she sought to argue that Mandy was particularly sort of coercive and controlling over Philip, and that actually, in actual fact, Philip was not indeed that close with Mandy and Ella. I mean, naturally, these points were disputed and rebutted with evidence, but nonetheless, Kylie sought to argue that owing to her close relationship with Philip, she was deserving of more from his estate. So at the time of presenting her letter of claim, Kylie's circumstances were as set out on the slide there. So she was 32 years of age, was married, had 3 minor children, husband in the military, and they lived in military housing. Kylie was a training nurse and due to qualify in 2023. She had an anticipated net income of £1,900 per calendar month, and her husband's net income was £1,600 per calendar month. Kylie sought to argue that she had debts of approximately £85,000, including car finance, student loan, credit card bills, and legal bills, should I say. And she tried to argue that she had an alleged income shortfall of £3,000 per calendar month, and that could be made worse owing to the fact that there was a risk that her husband was potentially going to be discharged from the military on medical grounds. These facts were again quite heavily scrutinised, as is always the case. But in applying the Section 3 factors that we spoke about earlier, so if I just back to Kylie's financial needs as a starting point, as I say, the financial disclosure was scrutinised quite heavily and proven to be inaccurate and quite heavily inflated, and having dug deeper and stress tested the numbers that Kylie put forward, it was disputed whether Kylie had any financial need whatsoever. It's also important to remember that Kylie was due to receive £100,000 legacy under the will, which is obviously quite a sizable sum, and that it was our position that this would have discharged Kylie's debts and left a surplus, which in turn would have opened up more income to her every month as well. Referring back to the case law that Georgie touched on earlier as well, it has been shown that awards in excess of £100,000 are quite rare, albeit the size of the award will be influenced by the size of the estate. So they were the points that were kind of primarily considered in terms of Kylie's financial needs. The financial resources and needs of any other applicant and beneficiary. Well, arguably Ella, as the daughter of the deceased, would have had a competing claim for financial provision if the matter was litigated, as Ella was financially dependent on Philip and lived at the family home, and obviously Mandy, as the surviving spouse, was also dependent on Philip too. So there was those factors to consider. The obligations and responsibilities which deceased had towards any applicant or beneficiary. Well, as we've stated, it's not enough just for somebody to say, I'm a child of the deceased and therefore I'm entitled. They need to be able to demonstrate something more. In this case, obviously, Kylie was competing against a spouse and a spouse of a lengthy marriage, so that always made her claim more challenging. Particularly when you consider that Mandy was financially reliant on Philip and was going to be responsible for the quite sizable mortgage on the matrimonial home after Philip's death. So Mandy and Ella, as I said, lived at home and were both reliant on Philip for housing and income from the business. And there was also some doubt as to actually how close Philip and Kylie were. And it was argued that in any event, that £100,000 gift that was left to Kylie under the will discharged any obligations that Philip may have owed. There was also a letter of wishes prepared by Philip alongside the will, which set out that, in his view, Kylie had proven herself to be capable of sort of looking after herself and her 3 children, and that she was financially independent. And it actually drew a sort of direct reference highlighting that Mandy and Ella, in the converse, were financially dependent on him to meet their needs. Size and nature of the estate, one of the other Section 3 factors. Property passed by survivorship, but as I said, was subject to a mortgage, and Mandy was going to be responsible for that mortgage thereafter, which then left a net estate of around about £650,000, which was predominantly made up of the value of Philip's shares in the business. But it was one of the arguments that we put forward was that the business could only really be run with Mandy and Ella's continued involvement. So that was also a factor that play in this case. There was no physical or mental disability to take into account here. Any other matter, including conduct, well, Kylie's something more than a mere blood relationship here was that she was arguing that although she already had a strong bond with Philip, she felt that she would have had a much stronger relationship and would have received more from Philip's estate had Mandy and Ella not deliberately trying to force that estrangement. But as I said earlier, that was firmly rebutted with evidence. The Section 3.3 factors as well. It was highly questionable whether Philip maintained Kylie in any way. There were some small ad hoc gifts over a 5 or 6 year period, but as I mentioned, they were primarily for Kylie's children rather than Kylie herself. And so we sought to argue that those small ad hoc gifts didn't really constitute maintenance. And again, referring back to Philip's letter of wishes, he quite clearly set out his rationale for structuring the will in the way that he did. And on the basis that there was no dispute around the validity of that will, it would, if the matter had been litigated, it's fair to assume that letter of wishes might have carried some weight as well. So in terms of the outcome, as it says there, a bit of a humble brag, but we sent a very strong letter of response to Kylie and her lawyers, and ultimately it resulted in Kylie essentially abandoning her claim, and it was settled prior to mediation on the terms set out on the slide. So yeah, Kylie walked away with her £100,000 gift as per the will, and it was agreed that each party would bear their own legal costs. So yeah, quite a costly exercise really for Kylie, and highlights some of the risk attached to pursuing these sorts of claims where they're not particularly meritorious. So to summarise and to bring things to a close, there are a growing number of claims generally, and that's perhaps, well, there's multiple reasons for that, but there's growing coverage of these cases. There's a sort of growing sense of entitlement, I think, for children, and particularly in light of the kind of economic challenges that we're experiencing in today's economy. And also there's more blended families as well. So the outcome being that there's more cases being brought, and so as a consequence, it's important to be alive to potential claims and how to mitigate the risks of claims being brought. For those attendees who are will writers, it is difficult. I appreciate that it's a difficult position, really, as the merits of any claim are based on the facts at the time of the hearing rather than the facts at the time of preparing the will, for instance. And it's impossible to see into the future, and circumstances can obviously change between the time of writing a will and the time of death, or the claim being brought. But it's important to nonetheless try and keep an eye out for potential claims when giving your advice, and consider obviously ways in which you can reduce the risk of claims being brought. So in terms of tips, I suppose, one of the sort of fundamental ones would be to undertake a sort of thorough fact find, and where children are concerned, into children's circumstances, and particularly where obviously children are being disinherited, and equally important to understand whether the testator is financially maintaining anyone at the time of preparing their will. A point which always seems to feature in these sorts of talks as well, but continues to stand true, that is the importance of making contemporaneous notes and keeping those on file. Thorough notes can help to diffuse claims or prospective claims very quickly, and so ultimately that can help to keep the cost down in these sorts of disputes as well, or enable us to reach settlement much more promptly as well. Ultimately, your notes as will writers are the only sort of insight into the testator's mind, really, at the time of preparing the will, so they play a really important role. And if there are no notes, then it leaves things more open-ended, and it leaves it means that the cases there's more scope, really, and they're more susceptible to debate or argument as to what the testator's intentions or wishes were. In terms of other small practical points, obviously there's the deadline for 75 Act claims, 6 months from the date of the grant of probate or letters of administration. So that's always something to keep in mind. That's a factor that will always play a part. Costs in litigation. Again, that's always a central feature, and it can be either a sort of a sword or a shield, depending on the strength of the case. But linking that back to the earlier point, if we've got a full and comprehensive file with lots of notes, then that can help to bring prospective claims to a swift conclusion and save on costs. And just to sort of really summarize and bring things to a close, just to reiterate, there is no automatic entitlement for independent adult children. They are needs-based claims, but they will typically need to show something more than just a mere blood relationship. And as it says there, case law has shown that it is difficult for independent adult children to succeed in bringing claims under the 75 Act, but equally is not impossible. And then finally, that each case will ultimately turn on its own facts. So it's important to seek specialist early advice, and because that will help to ensure that these cases are managed and dealt with proactively, and resolved quickly and efficiently, hopefully. So that brings us to a close. So I'll pass back to you, Lindsay, if that's okay.
Yeah, thank you so much, Henry and Georgie. That was really informative. I have popped a link to the 1975 Act resources on the IDRN in the chat. So if anybody would like to access any of that, please do just click the link and register. It's all completely free. If you've got any questions after the session, Henry has just popped a slide up with his and Georgie's emails, so just contact them direct. I'm sure they'd be happy to help. Just a quick one before everybody rushes off to have their lunch and stuff. We are now providing CPD certificates for our contentious clinics, because we've had quite a few of you asking about receiving those. So if you would like to get a CPD certificate from today's session, if you could contact Laura, our referrer manager, on the email I've popped in the chat, then she will provide you with one. So that's laura.reed@idrlaw.co.uk. Our next session will be recorded and will be brought to you by Eleanor Stenson, one of our partners at IDR Law, and she will be providing a summary of the litigation process and the particular steps that are required for the 1975 Act, and that will include a roundup of potential outcomes and orders. So please do join for that one. However, it is going to be recorded and we will be back live from June onwards. But thanks again for joining, and yeah, any questions, please do contact us and we'll see you next time. Thank you.